Hi everyone, and welcome to the CRIJ 3326 Criminal Law Review held for Senior Seminar. It's Dr. Klein again, and I will be holding this review for you all today. In today's lecture, I'm going to refresh your memory regarding the concepts and information that we previously discussed in the criminal law class. If you have any questions about the material, please don't hesitate to contact me, as this material will be covered on both the capstone exam and the major field test. Let's go ahead and get started on today's review. To begin with, we have to remember that there is a difference between criminal and civil law. Criminal law involves cases where the state has been wronged. The state has a vested interest in keeping citizens safe. That's why we have the police and correctional facilities. Even though the crime might involve a specific victim, the state envisions itself as the victim. That's why all state cases involve the defendant versus the state of Texas, for instance, or the defendant versus the United States if it's federal. Civil laws are a little bit different. Civil law involves disputes between two people, and the state does not have a vested interest here. For example, let's say I run over your mailbox. Maybe you're going to sue me for those damages. The state doesn't care that I ran over your mailbox, but you sure do, and you want your money back. Clearly, this is a very inexpensive example, but let's say your name is O.J. Simpson, and you were just acquitted in criminal court for the murder of your wife and her friend. But the families of your wife and her friend are still looking for justice, so they choose to sue you, and now you have to pay $25 million in damages. This is an example of what happens when both avenues of the court are utilized. We now know that you can be charged in criminal court and also sued in civil court, but the decision-making process is a bit different in the two courts. For the purposes of this review, we are only going to continue our efforts in looking at criminal law. The first thing that all crimes need is the act. Without an act, we don't have a crime. Remember that actus reus simply means the criminal act. The criminal act can either be a physical action or an inaction. If we have a duty to care and we don't act on that duty, that's a crime as well. But for the most part, we're talking about a purposeful act with intent behind it. The intent to commit a crime is considered mens rea. And that could come in a few different forms, such as knowingly, recklessly, or negligently. Finally, we have to make sure that those two coexist at the exact same time. So when I committed the act, the intent has to be there at the time of my action. For example, if I break into a building, my act, in order to steal the electronics that are found there, my intent, then I have what we call concurrence. If I break into that same building, that's my act, in order to seek relief from the outside elements, my intent, then there is no intent to be able to prove me guilty of burglary. There also must be causation of harm. The court has to prove that my direct actions caused harm to the victim, such as the financial loss that was incurred when I stole the television. But sometimes intent doesn't matter. If it was an accident, but something significant happened, I might still be guilty due to strict liability. For example, if a pedestrian runs across the sidewalk while you're driving through a yellow light, then you could potentially be guilty of involuntary or negligent manslaughter. Even though the intent wasn't there, you still ran a yellow light and ended up hitting a pedestrian with your car. Strict liability allows for prosecutors to find individuals guilty for lower level crimes even though the mens rea is absent. Once you are charged with a crime, you have the right to defend yourself in court. It is not a requirement to do so, as the state is the one that has the burden of proof, but it would be smart of you to provide a defense in court. With some defenses, you're simply trying to convince the court that you aren't guilty because there isn't enough evidence stacked against you, and you're trying to win the case that way. However, sometimes you have to provide a different style of defense because there is strong enough evidence to link you to the specific crime. In this instance, the defense could come in the form of a justification or an excuse defense. In both of these styles, no one is really proving that they didn't commit the crime. With this style of defense, there is a certain level of admittance that the defendant did commit the act, but they are still not guilty for the specified reason that they provide in court. The defendant is the one who is responsible for providing that defense. the defendant has the burden of production or of persuasion. In using justification defenses, the defendant is trying to explain that my behavior was warranted given the specific circumstances in question. This means that the defendant has to provide some evidence in support of the defense. For example, I'm not criminally liable for my victim's death because I was justified in my actions. It's generally wrong to kill someone, but they broke into my house in the middle of the night and I had to shoot them in self-defense. It wasn't wrong for me to break out of prison because the other inmates were trying to kill me. These are two examples of justification defenses. On the other side of things, excuse defenses show that the act was terrible and that it should be a punishable offense. But there is something about my personal characteristics that should exclude or negate my liability. For example, I cannot be held criminally liable for this murder because I suffer from a severe mental illness. I was under the influence of narcotics at the time of the crime. I had a really bad reaction to my prescription medication and I couldn't control my actions. I'm not arguing that I didn't commit the crime, just that I'm not liable for it. Within the excuse defenses, we could break it down a little bit further. Some of these are a little self-explanatory. The insanity defense implies full legal insanity. It is a difficult process, but you're basically trying to establish that you were legally insane at the time of the offense and cannot be held liable for your actions. Diminished capacity does not infer legal insanity, but it does infer that there was a mental break or a mental illness present at the time of the offense. Involuntary intoxication implies that maybe I drank too much or I used too much of an illicit substance and then I went out and committed a crime. This type of a defense normally doesn't work too well in courts, but it is something that you could try and use. Voluntary intoxication leads to involuntary actions. Involuntary actions is a defense that you could use more successfully in court. In this instance, you can make the argument that someone slipped something into your drink, they drugged you without your knowledge, they forced you to consume something, or that maybe you took the wrong medication. For instance, maybe you confused a sleeping pill with your cholesterol medication. The final defense rests with age. If you are a minor being charged as an adult, you could make the argument that you aren't old enough to form mens rea and therefore are not liable. One of the biggest safeguards that we have regarding new laws is the idea of ex post facto. Ex post facto protections make certain laws illegal because you cannot retroactively punish someone for an act that was legal at the time it was committed. In other words, you cannot pass a new law on Friday and apply it to everyone who committed the action on Thursday. When laws are criminal in nature, there are a few limitations in regards to what is permissible under ex post facto. The first is the scenario I just described. If I committed the crime before the law was passed, then you cannot prosecute me for it. The same goes for aggravation of a crime. If you change the law to make it greater or more severe in nature, then I am still free from prosecution under the new terms if it was committed while the law was written this way at the time I committed my crime. It is also illegal to make a punishment harsher if the law called for a more lenient punishment at the time of my offense. Finally, it is also illegal to alter the rules of evidence and have them apply retroactively. If a certain crime were to require mandatory DNA evidence, you cannot require that of me if it wasn't a requirement previously. The only time in which ex post facto would not be violated is when the law is applied positively in nature and would make things less punitive for those in question rather than more punitive in nature. In order to explain the different parties of crime, I always like to use the example of a bank robbery to better explain these different roles. So let's begin with our principal in the first degree. This is our main perpetrator. Let's pretend for a minute that I'm about to have my house foreclosed on. In order to avoid that foreclosure, I need to come up with some big money and I need to come up with it very quickly. Even though my job pays well, it doesn't pay nearly enough and it doesn't pay me that quickly either. What am I going to do to find enough money in such a short amount of time? Then I figure it out. The bank. They have tons of money in the bank with the amount of deposits that they take in a day. I'm going to rob the bank. And then I think about how complicated that can be, so I need to create a plan to do this well. So it's going to involve recruiting some friends to help me out. And that's where others step in. I'm the main perpetrator, or the principal in the first degree, but I can't do it on my own, so I need to find some accomplices. What if I knew my best friend would be willing to help, and just so happens that he is an expert safecracker? Isn't it convenient that I have such good friends? So let's say that I approach my best friend and I tell him my idea to rob a local bank. Then I tell him my plans and he's all about it. He thinks it's an excellent idea. You'll remember from previously in the class that we have now formed a conspiracy. Once my friend agrees and we start to plan our robbery, he has become a principal in the second degree. He's going to help me plan and even agrees to physically be there on the day of the robbery. By being physically present, he would equally be liable for the crime in question, meaning he would be charged with bank robbery. If he wasn't physically there, then he would not be charged as highly, meaning he would only be charged with conspiracy to commit the bank robbery. Finally, we have two more classifications of co-perpetrators. So let's say that even though my best friend and I are planning to rob this bank together, we decide that we need more help. He suggests that we need ski masks, firearms, and tools to help us crack the safe if we cannot convince the bank manager to open it for us. And where are we going to get these things? Well, my best friend just happens to know a guy who can get all of the necessary supplies for us. Once he asks him, he gives all of the supplies to us, and he becomes an accessory before the fact. In order to meet this classification, you have to either help plan, provide supplies, or do something else to help aid the principal actors before the crime takes place. It is not required for the accessory before the fact to be physically or constructively present like it is for the principal in the second degree. Finally, we have to make sure our tracks are covered once we commit the robbery. This means that we need someone to help hide us from the police. I just happen to have another friend who has a couple acres outside of town where we can hide out. I asked my friend and they agree. So while we're planning to hide out there, that's where we're going to go after we successfully rob the bank. We didn't ask anyone to be a getaway driver because we think we can get out in time on our own. But my friend who owns the safe house has now become an accessory after the fact. I've told them that I plan to hide out there after the robbery and they agreed. They are aware of what I'm planning to do and they have agreed to keep the police off of my trail if the police happen to show up at the safe house. It is very important that this individual knows that the crime has occurred in order for them to get charged. Let's say I did try to secure a getaway driver, but I never told him about the crime. I just asked my friend for a ride home from the bank at a very specific time. If my friend agreed to do this without any knowledge of the robbery, then they would not be held liable. They have to be aware of the crime to be held criminally liable. This is an important point for you guys to remember. Modern classifications only place individuals into two categories: accomplices, who are the principal in the second degree and the accessory before the fact, and accessories. This is our accessory after the fact. You should all be aware of these categories and classifications and where everyone fits in the more traditional and the modern classification structures. To begin with, when we have this discussion of the categories of crime, we have to focus it within the sphere of what we call inchoate crimes, or beginning crimes. If these are beginning crimes, which means that would imply that there is more to come. That's one of the reasons why these are separate charges listed from the actual crimes that are committed. You might not actually get to commit the crime, or you might get caught trying to do it. So think of this portion of the lecture as all of the prep work that is needed to go out and commit all of the other specific crimes that we discussed in our criminal law class. Attempt is our first one. This means that it's an incomplete or unfinished crime. Conspiracy means that you and I are working together in agreement to complete the crime. And finally, there's solicitation. This implies that I asked you to work with me or for you to commit a specific crime like burglary for me. Potentially, all three of these can happen at one time. Let's say in this example, I want to hire someone to kill my husband. I found someone who I think would be willing to do it for me. I asked them, and I offered them $10,000 in exchange for the killing. You do not need to agree in order for me to be charged with solicitation. However, once you agree to perform the task and you accept the money, then you and I have entered into a conspiracy. If you then go out and try to kill him, but he doesn't die, then there is attempted murder added to your list. Think of all of these as very separate charges that are somewhat connected together in some way. Speaking of murder, it's time to discuss homicide. When we talk about murder, there has to be intent. Just like all of our other crimes, there has to be intent to kill someone else. Intent is demonstrated by what we call malice aforethought. This is us leaning towards premeditation, meaning that I have a plan, I have specific intent, I mean to kill you, and it is demonstrated by my actions to complete the kill. First degree or capital murder is considered the worst form of murder possible. Different states will call it different things, but for the most part, this is the one that's going to get you the death penalty if you're in a death penalty eligible state. There are two requirements for first degree murder: planning and carrying out that plan. Premeditation is considered the planning stage of the crime. Legal statuses do not require that the plan be long and drawn out, or that I have to plan for a considerable length of time. I might think about the murder for a split second. I see the victim standing right in front of me. I go get the firearm from the bedroom and I shoot you in the kitchen. That could be the extent of my plan, but it is enough to fulfill the requirements for premeditation. Deliberation, on the other hand, requires that the offender be in a cool state of mind when the murder occurs. If the offender was provoked, was angry, was overly emotional, or in some other state that was triggered by a situation, then they would not be guilty of first-degree murder. Voluntary manslaughter charges exist for those crimes that are not committed in a cool state of mind. With second-degree murder, we see some differences popping up that weren't there for first-degree murder. First, there is no premeditation like we saw with first-degree murder. So there is no plan in place to commit the killing. Instead, we still see that there was intent to harm somebody, but maybe not to kill them. I know that my behavior can result in your death, but that's not my original goal. My original goal is just to inflict harm or cause damage that is dangerous in nature. For example, what if I were to commit arson knowing that there may be people still in the building? I may not want anyone to die, but I just lit an apartment building on fire, and I know that there are residents who might be home in the building. That's second-degree murder. Next, we turn our attention to felony murder. Remember that we have discussed felony murder when we discussed first-degree murder in class. But we need to figure out the components of felony murder and who can be charged when it occurs. First, as a review, felony murder occurs when I commit a felony. Typically, these are dangerous and forcible felonies. While I am committing that felony, a murder occurs, whether I intended for that to happen or not. Finally, we have to discuss voluntary and involuntary manslaughter. With voluntary manslaughter, there is not enough time to formulate a plan or to have any sort of premeditation come into play. This is a reaction that comes from a specific situation that you have encountered. This one needs adequate provocation. Mostly when we speak of adequate provocation, we mean crimes that are committed within the heat of passion. Let's use the classic example of a wife finding her husband in bed with another woman. She goes crazy. She takes a gun out of the nightstand, shoots both people in the bed, killing them. She did not intend to find these two individuals in their bed. She did not intend to kill them. But circumstances happened, as they did, and she killed them as a reaction to the anger that she felt. She was not in a cool frame of mind. We see this happen with adulterous situations, in instances with aggravated assault or battery, or when mutual combat occurs and things escalate into a death. The important part to voluntary manslaughter is the heat of passion issue. If there is any time to cool off and you take that time and then you come back, the murder is no longer voluntary manslaughter and can be increased to the level of homicide you are charged with. For example, if that same wife were to run out of the bullets, leave the room, reload the gun, come back into the room and start firing again, then this has the potential to be first-degree murder due to premeditation kicking in. Finally, we have involuntary manslaughter, which is most commonly associated with drunk driving and someone dies. I didn't mean for it to happen, but I was intoxicated and killed someone with my car. Some states include vehicular manslaughter within involuntary manslaughter statutes, and others will keep them entirely separate. Finally, one of the last things I want to talk to you guys about is the idea of assault and battery. Typically, when you hear these two terms, you think about them together, don't you? Almost as if they were the same crime. However, they are two distinct charges. With battery, you must make contact with a person, whereas with assault, it's not needed. I have to hit you in order to be charged with battery. But note that in this definition, it has to be offensive contact that a reasonable person would find offensive. Technically, if I poke you with my finger, that would be considered offensive touching, but would a reasonable person think so? Probably not. The reasonable person standard would certainly apply to things like slapping, punching, biting, kicking, things like that. So when you think about battery, focus more on the idea of bodily injury rather than just simple touching. I might not be the one to physically make contact with you. If I am the cause of your injury, then I would still be the liable party. For example, if you ended up getting hurt because I bombed a building, battery is only going to be one of the many charges that are given. There might be murder charges available too if people die, but at the very least, battery charges for those people who were injured in the blast. Or let's say that I own a pit bull. He might be really cute and docile most of the time, but for many people, he's still considered a very dangerous breed. If he were to get out of the backyard and he bit someone, then I would be held responsible because it's my dog. If my dog, or my animal rather, does something and you end up hurt because of it, then I can receive battery charges because my little dog hurt you. I am the responsible owner, so the criminal charges come my way. The very last topic that I want to briefly review with you guys today is the idea of sexual battery and sexual assault. Very similar to non-sexual battery and assault, these two offenses are very similar in nature, but there is one distinct difference between them. Sexual battery is what we more commonly refer to as rape, but it is codified as sexual battery for criminal prosecution purposes. Really, the term rape is more antiquated from a prosecutorial standpoint. It's very easy to differentiate sexual battery from sexual assault. Sexual battery involves penetration, but sexual assault does not. So sexual battery is really rape, meaning that there is penetration of the victim's mouth, anus, or vagina from the offender's sex organs or by some other foreign object. And sexual assault is all other types of non-consensual sexual contact that does not involve penetration. There are actually two lines of thought when it comes to force and how much force is needed in order for rape to be considered forcible compared to other types. First, we have the extrinsic force approach. Extrinsic force occurs when I have to take some sort of extra action in order for me to successfully complete the rape. For example, let's say that I have to restrain you or tie you up or threaten you with a weapon to complete the penetration. That's an example of extrinsic force. Extrinsic force often results in injury to the victim beyond the rape itself, such as receiving knife wounds, being beaten, or maybe even being killed during the rape. Next, we have the idea of intrinsic force, which differs in the amount of force necessary to complete the rape. Here, the rapist only exerts enough force to be able to successfully rape the victim. There's no additional violence, there's no coercion present. Intrinsic force only relates to the rape itself. So this means that I could be drunk or I could be asleep and that it occurs. But what is most important here is the lack of affirmative consent, which is always absent when a victim is unconscious. So that's the gist of what I have to review with you guys today. Hopefully you have all saved your materials from the criminal law class and are able to continue to study those materials here in senior seminar. Although this review is rather detailed, I won't call it comprehensive by any means. There still may be information on the capstone or the exam or the major field test that was not covered in this lecture. If you have any questions about this review or anything else criminal law related, please be sure to get in touch with me before you take the capstone exam or the major field test. Thank you guys for your time and your attention today. Have a great day, everyone. Bye.